Ms. Rahayu.
Mr. Deputy Speaker, I first declare my interest as a practicing lawyer. In recent years, great strides have been made to strengthen access to justice to the public. Enabling access to justice must remain a cornerstone of our legal framework, as robust and efficient dispute resolution greatly aids businesses and consumers alike. I am therefore pleased to hear of the amendments to the Small Claims Tribunals Act to strengthen access to justice in Singapore. I note that in 1984, the Small Claims Tribunals, through joint efforts of the Ministry of Law and Ministry of Trade and Industry, were introduced to allow for speedy and inexpensive machinery to handle small claims arising from disputes between consumers and suppliers. It sought to ensure that A. There is consumer protection with speedy dispute resolution that is not belaboured by strict rules of evidence or court procedures. B. Cost is kept to a minimum. And C. A litigant in person is not disadvantaged by the inability to afford legal representation. As we review the existing Act, we should continue to be guided by these principles. In this vein, I have some comments to make in relation to some of the proposed amendments in this bill. The jurisdictional limit of the Small Claims Tribunals was $2,000 in 1984. This limit over time has been increased to $10,000. The amendments propose an increase in the quantum of jurisdictional limit to $20,000 by default and up to $30,000 if parties agree to the same. This is welcomed. However, it is notable that the last revision on the limit was done in 1998, almost 20 years ago. Some may express concerns that the proposed limit is still too low, especially as litigation costs, even for claims slightly above $30,000, can sometimes be quite high. On the other hand, lawyers may feel that more work is being taken away from them as more processes are made simpler for litigants in person. I note that there will always be challenges as we seek to set limits. I trust, however, that the Ministry remains open to review this limit at the appropriate junctures. The limitation period for bringing a claim to the Small Claims Tribunals has also been increased from 1 year to 2 years. This is a good alignment with the limitation period for bringing claims in other tribunals in the state courts. Additionally, the amendments also seek to broaden the types of claims that can be heard at the Small Claims Tribunals, such as hire purchase claims, in addition to pre-existing categories, such as any contract for sale of goods or provision of services, or claim in tort in respect of any property, and contract for the lease of residential premises that does not exceed 2 years. While the inclusion of hire purchase claims is a welcome addition, another common area of need for many Singaporeans is a platform to resolve disputes arising from personal loans. Currently, when parties enter into IOUs or written personal loans, they are unable to use the Small Claims Tribunal to assist with resolving their dispute. Previously, members of this House had also asked about platforms to arbitrate personal injury or property damage claims relating to the use of the personal mobility devices. As the needs of Singaporeans continue to change, we must constantly evaluate the types of claims that can be arbitrated under the Small Claims Tribunals. I therefore urge the Ministry to consider including some of these claims, perhaps in the next review or amendment of the Act. This amendment also seeks to empower the tribunals to award costs against parties where necessary. Currently, the tribunals does not have the power to make cost orders except when the claim brought forward is frivolous and vexatious. This was envisioned to give the litigant in person with genuine claims a peace of mind to air their concerns and be given an opportunity to be heard. Often, litigants in person may be unable to see the other party's perspective easily and may be overzealous in pursuing their claims. I would urge that the exercise of these powers to order costs be done very judiciously so as not to penalize laypersons too quickly. I also support the enhancement for the tribunals to order mediation. As a mediator, I definitely see value in mediation being a key step in dispute resolution. Mediation is, however, a consensual process. I therefore hope that in mandating mediation within this process, the tribunals take the effort to ensure that parties understand and appreciate the purpose and value of mediation so that they are attending such mediation sessions with an open mind to resolving such disputes. If it becomes clear that the gap between parties is too big, then mediation may not be the most appropriate option and parties should be able to go through the process without any delay. Currently, there is no avenue to appeal unless there is a question of law or unless a question of law or jurisdiction arises. This has led to some dissatisfaction by some who have come before the tribunals. It is a fine balance between providing finality of outcome and ensuring just outcomes. In this regard, I am happy to note that the District Court would be empowered to remit a matter to the Tribunal for reconsideration or order a rehearing by a different tribunal and grant a stay of execution where appropriate. It may be useful to give litigants in person more time to file a notice of appeal, especially where they are seeking determination on a question of law or jurisdiction. 14 days may be too short a time to seek legal advice and prepare the notice of appeal. As the tribunals will be a place where the public interact with the justice system to seek recourse for their grievances, we must also evaluate the experience one goes through, and often this experience can greatly impact one's impressions of the justice system. I'm happy to note that the tribunals will be empowered to issue its own practice directions, which will be made available to the public. I trust that these practice directions will not take the usual form as the ones issued to legal practitioners and will be easy and simple to follow. Since 10th July 2017, the Community Justice and Tribunal System, CJTS, allows for parties to file claims from the comfort of their homes. It is also important for this system to be supported by a call center where calls about procedure are dealt with. I believe this is similar to the suggestion by fellow member Ms. Joan Pereira. These calls can be managed by a trained pool of paralegals who may be in the best place to assist. At the small claims tribunals, we must continue to remain open to assist those in need of guidance, keeping in mind that such officers can render legal advice. In conclusion, while the proposed amendments greatly enable access to justice, we must continue to create awareness about such resources amongst our residents. And minimally, the information about these tribunals should be available at every community club. The awareness is a critical enabler to access to justice. Mr. Speaker, Mr. Deputy Speaker, I stand in support of this bill.